The case of _McLoughlin V OBrian _1983 is a landmark House of Lords decision that significantly expanded the circumstances in which a claimant can recover damages for psychiatric harm, historically referred to as nervous shock, in the tort of negligence. It established that a duty of care could be owed to a person who suffers psychiatric injury as a result of an accident involving a loved one, even if they were not present at the scene, provided they witness its immediate aftermath. Hello and welcome to Landmark Case Laws Simplead. Buckle up as we explore the fascinating world of McLoughlin v OBrian together. The case arose from a tragic road traffic accident. The accident, on the 19th of October 1973, the claimant's, Mrs. McLoughlin's, husband and 3 children were involved in a serious car accident. Mrs. McLoughlin was at home, approximately 2 miles away, at the time of the accident. She was informed of it by a neighbour around 2 hours later and was driven to the hospital to see her family. At the hospital, she learned that her youngest daughter had been killed. She then saw her husband and her other 2 children, who were seriously injured, covered in oil and mud, and in great distress. This experience caused her to suffer severe shock, leading to clinical depression and a personality change. The House of Lords found in favour of Mrs. McLoughlin. The leading judgment was delivered by Lord Wilberforce, who established that while reasonable foreseeability of psychiatric harm is the primary test for liability, it is not unlimited. To keep liability within manageable bounds, he laid down a 3-fold test, often referred to as control mechanisms, which a claimant must satisfy to be considered a secondary victim. 1. Class of persons, relationship proximity. There must be a close tie of love and affection between the claimant and the primary victim. This is presumed for spouses and parents, but other relationships, e.g., siblings, engaged couples, must be proven. A mere bystander would not qualify. 2. Proximity in time and space, temporal proximity. The claimant must be close to the accident in both time and place. A key expansion from previous law was that this could be satisfied not only by witnessing the event itself but also by coming upon its immediate aftermath. In this case, seeing the results at the hospital 2 hours later was still considered part of the immediate aftermath. 3. Means by which the shock is caused, perceptual proximity. The shock must come through the claimant's own sight or hearing of the event or its immediate aftermath. It cannot be communicated by a third party. Mrs. McLoughlin's injury resulted from what she personally saw and was told at the hospital. _McLoughlin v OBrian was a pivotal moment in this area of law, moving beyond the need for physical presence at the scene. The House of Lords also addressed and dismissed the floodgates argument, the concern that allowing such claims would open the way to limitless litigation. The principles established in this case were later refined and affirmed by the House of Lords in the leading case of Alcock v Chief Constable of South Yorkshire Police, 1992, which concerned claims arising from the Hillsborough disaster. The control mechanisms from _McLoughlin remain the foundation for all secondary victim claims for psychiatric harm in English tort law today. Thanks for watching.